Mr. Gallman, and Mr. Player. All three of these are have one underlying matter related to it. Would Mr. Player, would you like to come first?
That's fine. Good afternoon.
I'm sorry, your name, sir?
Tucker Player.
Mr. Player, would you raise your right hand?
Yes.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Thank you, sir.
I provided a summary of my testimony.
Sir,
Oh, sorry.
if I may begin. Mr. Player, the commission has before it your affidavit of complaint, which I respectfully request be made part of the record at this time. The purpose of today's hearing is for the commission to review the qualifications of the candidates to determine whether Judge Bromell Holmes is qualified to be on the Court of Appeals. The commission is not here to relitigate a case, and they do not have the ability to change the result of the case. Mr. Player, you submitted your affidavit, which the commission is reviewing. Is there anything else you wish to testify to specifically regarding Judge Bromell Holmes' ethics, competency, or character that has not already been covered in the documents before the commission?
Just a few things. I won't go through the entire summary of testimony. I'm here on behalf of myself, I represent John Gallman in civil matters. I did not represent him in family court. I don't do family court. I've never seen Judge Holmes until today. My concern and the reason I'm here is the order that I attached, because to me, an order like that can't be issued by a judge that sits on a court of appeals. Primarily, I'm focusing on two things. It's either temperament or professional and academic ability, because of three things. The number one is real simple. She ordered that a father of a 9 and 10-year-old could not communicate with his children for a year. For a year. If any of you can extrapolate that or justify that as in the best interest of any child, I'm all ears. But that is the primary focus of why that order disqualifies her from serving on the Court of Appeals. The other two issues border the line between knowing the statutes and her temperament, because one of her findings for issuing the order, which prohibited these children from speaking to their father for a year, was that he took her to MUSC for a physical evaluation after finding bruises on her thighs. The reports that came from MUSC were mandatory, statutory reports from the providers that are covered under the statute. So Judge Holmes either didn't understand the law or she didn't care what it said when she said, when you took them to MUSC, that was wrong and I'm taking your kids. So,
Senator Sal.
Attorney Clay, if you don't mind, let me just, I hate to interrupt, but I was curious about your first point regarding no contact for a year. Was there a condition precedent of some sort of evaluation or test that that the defendant was supposed to avail himself to and he didn't, or did I misread?
no, that was there. It was during the pandemic, and it went on for a year, during which he twice went back and requested that he be able to speak to his children. You know, wish them happy birthday, Merry Christmas, stuff like that.
But was there something that the judge required that he was supposed to comply with, and then once that's complied with, then the issue of visitation and those kinds of things would be visited?
Right, but see, using the father's failures to punish the children is my problem with the rule.
Well, but stay with me a second. Just stay with me a second. I'm not casting judgment. I understand you've got an opinion based upon a relationship that you have with a client. And I guess for me, and I wanted to just address that issue, because there are condition precedents oftentimes in several of our jurisprudence as it relates to a lot of areas where one thing has to be done before something else. And typically, I mean, my approach has been, even if we disagree with it, let's do it, get it out of the way, and then let's focus, because not only should the judge be interested in a parent having access to their child, the parent also would be interested in having access to the child. And so if there is a condition precedent, to the extent that it can be met, if it can't be met, then that's a different issue with me. But if it's just a condition precedent so that I can have access to my children, and that's of paramount importance to me because it irreparably harms me and my children, then to the extent that that's something that is within my power to do, I simply do it, whether I disagree or not. I mean, do you think that's a reasoned approach or not?
Not when there are 9 and 10-year-old involved and they're,
Come on, let's not focus on how old the children are. I'm specifically interested in the condition precedent.
right, and that would be a legal technicality that I think has absolutely nothing to do with the best.
How can you
interest
say
of-
it has nothing to do with it?
Because
when
it's not
a
in
part-
the order. Show me in the order where she gives, what is
No,
your
I'm-
justification for saying no communication with the children? That's what I'm asking for.
Okay,
If
so-
somebody can give it, then vote her into office.
My point was very narrow. And I was just trying to get you to address that narrow issue. Not the global thing, because I intend to hear you out.
Sure.
But on that particular issue relating to the condition precedent, that's what I wanted to drill down on.
And I guess it's an issue of balancing, because you're right, if the court orders you to do something, you have to go do that.
Right.
A condition precedent, yes, but in this situation, to me, from reading the order and the lack of what I see as a legitimate basis for that harsh of a restriction,
So
At
let me
some point-
intervene if I could. Mr. Rutherford, you have a question?
Yeah, I mean, Mr. Player said that if we could point it out, in number 7 on whatever page 3 or 5 with Jan Holmes, I assume her initials. Court is concerned that the minor daughter has been subjected to ridicule by a paternal relative for not substantiating the alleged abuse as stated by the father. The court is further concerned about the minor daughter's alleged sucking of the thumb as stated by the father. The minor daughter has expressed discontent with the father as to his actions. The minor son needs counseling for anxiety stress. Number 8, that defendant father is to have no visitation with the minor children, no telephonic contact or electronic contact with the children, and will not participate or attend any of the children's extracurricular activities, appointments, or events. So number 7 precedes number 8. And number 7 seems to be her rationale for ordering number 8, and then goes on to number 9, that they participate in psychological custodial evaluation, which is what Senator Saab was asking about. So while we may disagree as to whether she should have done it or not, number 7 is her rationale for doing it, is it not?
that's legitimate, exactly what.
Whether it's legitimate or not, is that not what she stated was her reason for doing it?
And right, and it goes
So,
directly.
I'm sorry, wait, hold on. You seem to come for Senator Saab and state that she did this without any basis whatsoever. But you knew that number 7 existed on page 3 or 5, did you not?
I don't consider that to be legitimate.
Whether you consider it to be
No, you're
legitimate or
I'm
not.
not under
Wait,
cross-examination.
let me finish. Whether you consider it to be legitimate or not, you stated that she did not do exactly what she did in number 7. You didn't say she did it and I disagree. You said she didn't do it, and it's right here.
You're twisting my words, and it's not gonna work, Mr. Rutherford.
Listen,
Gentlemen, please. The focus of our inquiry today is the evaluation of the candidate with respect to the 9 constitutionally, statutorily mandated criteria that we are charged with the responsibility of evaluating.
Correct.
Now, we're not here to relitigate the case. I think you made your point, sir, that you think that she made these decisions without sufficient basis. I think Mr. Rutherford has raised concern about your allegation. That's what we're here to now hash that out. What I'd like to do though is.
wait, I'm sorry, Mr. Chairman, hold on, let me disagree with you for 1 second. Because
Please.
I stopped reading, and I should not have. Because number 9 says that the parties shall participate in a psychological custodial evaluation that will be submitted to the court prior to the defendant father having any visitation address with the minor children. Now, again, I don't know, I don't do family court, but that sounds like the condition precedent that Senator Saab was asking about. And again, I'm just sitting there perusing this stuff. I'm not saying that I don't agree with the testimony, but I am saying that what he is saying doesn't seem to mesh with what is right in front of us in the information that he was told that we have.
Yes, sir. I think you've now made that
Yes,
very
sir.
clear.
I'm not taking a point, I'm just reading what's here. So it's not my opinion, it's
At
what's
least he's
there.
reading it, so.
So we have what you've submitted in the record now. We have the benefit of your testimony. Is there anything else you'd like to add?
I just wanted to continue, because I was talking to Senator Saab about the weighing of the issues, but there's a give and take, and there was no give here. It was, he went back twice, I'm not sure what he testified to, getting this evaluation, but the entire time, these two children, 9 and 10-year-olds, don't have any communication.
Yes, sir.
with their
And
father.
again, you're not here to relitigate
Okay,
that.
sorry.
We made it clear that you have concerns about this litigation. We have the information in your affidavit and in the record now. What else?
Just the last issue is, of course, the whistleblower. I mean, you're trying to promote Judge Holmes to the Court of Appeals, and she doesn't know the law. She allowed a counselor to come into a court and violate the statutory law of South Carolina, and then she did it herself when she repeated it in her order. An LLR complaint is confidential, period. And she didn't know that, or she ignored it. And what I argue is the same manner in which she ignored the mandatory reporting. She blamed John for everything that arose out of a mandatory reporter by a provider. That, if you understand the law, you can't place blame with the father.
Mr. Chairman,
Yes, sir. Senator Sapp?
I just want to put a pin there just for a second.
Sure.
Now, typically, when the court rules, she assigns one of the lawyers to draft the order. Typically, the lawyer that drafts the order is required to share the order with opposing party. You agree with me on all of that?
Yes, sir. Yes, sir.
Do you know in this instance, which lawyer was asked to draft the order?
I believe it was his ex-wife, but I do not know for sure.
Okay, so then you had a lawyer to draft the order, to place that language in the order. You had another lawyer on the opposing side that read the order, and as far as I know, and you can help me if I'm wrong, did not put anything on the record in terms of any objections to anything in the order.
I don't think that's correct, but I don't have those documents before the court, and that quite, I'm not trying to be rude or dismissive.
No, you're fine.
My point is the original order. I just don't understand how that.
I'm with
order
you,
is-
I'm with you, but what I'm seeing is an issue that you're raising that's not only missed by the judge, assuming what we're saying is correct, but it's missed by the court, it's missed by the plaintiff's lawyer, and it's missed by the defense lawyer, because, come on, you and I are officers of the court, right? We have a responsibility, if we know that something is violative of the law, we have a responsibility to bring that to the judge's attention. You agree with me on that, right?
Yes, sir. I would have probably been in jail if I'd represented John in this particular situation.
I'm with you, but both lawyers would have had essentially a responsibility to make sure that that issue was protected.
I would agree in most circumstances, but in the family court setting, it just doesn't work that way, because if he would have appealed her order,
No,
saying
not-
he can't see the kids, he'd have had 2 years in no contact.
No, and I'm not gonna go there.
Okay.
I'm on your third issue now, relative to the violation associated with the disclosure.
Yes, sir.
My point is that you would have had the lawyer drafting the order that missed it. My words, not necessarily somebody else's, but included it in there. Then you've got the reviewing lawyer that, as far as we know, allowed it to be included in there. And then you've got the court ultimately signing the order that's proposed to her.
Yes.
That's the typical way. I wasn't there, you weren't there.
I'm assuming that, with your assumption that that's what was done
Yeah,
here.
yeah, because that's what typically occurs. And so I guess I just wanted the record to reflect that that's the process by which these orders are typically generated. All right,
Yes,
I'm finished with that, Mr. Chairman.
Thank you, sir.
I'm making you nervous, I'll be quiet
No. In fact, if anything, I was gonna quibble with, the introductory clause of your last, colloquy, which was that we're trying to promote her or trying to advance. Our charge is simply to evaluate the constitutional statutory.
now. Poor choice of words on my part, I apologize.
Okay, I just want to make sure that you and anybody else who shares your view, as I understand the other two complainants, we're just here to do our jobs to thoroughly investigate and hear out this thing. So
Yeah.
if anything, I'm grateful to you and others who've taken the time and effort to submit information to this commission so that we can then ultimately, hopefully, with the grace of God, arrive at the best decisions available, so.
You know, and going back to Todd and Senator Sabbs, there is a process, and sometimes things get lost in that process, but, you know, the 362 days, you know, they tried to intervene twice, and that restriction was never lifted. To me, I just can't understand a judge that sees that as the best interest of the children, and we're going to put her in charge of telling other judges what they should do in both the family court and the circuit court.
Yes, sir, I hear you. Are there any of the commissioners, Senator from Ori?
Mr. Blair, Luke Rankin,
Yes, sir.
we know each other, but we don't.
Yes.
Um,
Do we need JP here?
No. We'll let the court decide that, I guess. But my quick question to you, you don't practice in the family court arena?
No. And I don't know what Judge Holmes has said in defense, and she's probably gonna say it was a temporary hearing, I had what was in front of me. And quite frankly, that's a bigger problem in our system than anything else, if the judges are put in that position to make, I mean, I think twice we've heard today, two situations, a 15, 20-minute hearing, and the children are taken away.
You've never appeared before her in court.
No, that's the first time I've seen her today.
And you said this at the outset, you're not here on behalf of and being paid today by Mr. Gallman,
No,
correct?
sir.
All right, that's all.
Thank you, sir. Representative Rutherford.
Thank you, Mr. Chairman. Tell me about the LLR thing again. How did that come about?
A counselor that I'm not even sure my client made a complaint against, put an affidavit in court saying that John Gallman complained against her to the LLR, and then that was cited in an affidavit, which she then cited in an order.
And you are relying on the fact that the counselor mentioned the complaint as a reason that Judge Holmes should have ignored that and not mentioned it, is that?
Well, considering it was a confidential, statutorily protected information, she shouldn't have used it as a reasoning for taking his children away. She should not have mentioned it at all.
And let me get back to that, because, you know, the Supreme Court has weighed in, and, well, the court, federal court in particular, has weighed in on what is now confidential in these complaints. And what used to be confidential is held in confidence by the agency, but is not necessarily confidential as to the parties that are involved. Similar to an ODC complaint, which used to be confidential, but now the party that has had the complaint filed against them can talk about the complaint, no different than an ethics complaint, because you can't restrain the party that filed the complaint. And so restraining the party that has the complaint filed against them has been held to be unconstitutional. You're aware of that, right?
What year was, I'm not sure of the opinion.
Okay. So if we're not sure of the opinion, and we're saying now that a party in front of the judge mentioned that an LLR complaint had been filed against her, you're submitting that the judge should have ignored that?
Yes, it has nothing to do with the situation. You don't punish the children by taking them away from the father. Well,
But-
if he somehow, you know, acted inappropriately through making a statutorily provided for complaint, that's the other thing. It doesn't matter if it was confidential. He has a right to go make an LLR complaint, and he doesn't get punished for it by a judge who's trying to establish her power.
So, Mr. Blair, I'm not getting into the merits of it. I'm simply-
You're not?
No, sir. I'm suggesting that if you're alleging that she committed a clear violation of the law, I'm suggesting that it is not as clear anymore, because the courts have said that you cannot restrain speech. And in fact, even as it relates to lawyers, you can't restrain speech. Even as it relates to ethics complaints against members of the House and Senate, you can't restrain speech. And so I would submit that your assertion that Judge Holmes had to ignore that is not proper, given the fact that if one of the parties to the LLR complaint spoke on that in court, there's nothing that I see that bars the judge from hearing that and reacting to it. What she did with it, how that impacted the case, I'm not here to deal with that.
Yes, you are.
Simply as to, well, we may disagree on that.
No, you're
But
here to judge her
stop telling me
character
what I'm
and
here to
fitness.
do.
Mr. Player, we're gonna go one at a time, or we're gonna stop.
He's interrupted me pretty consistently.
Okay, well, we're gonna start over now, and I'm gonna say, Mr. Rutherford gets to talk until he's done, and then you're gonna get to talk until I think you're done, and then we're gonna move on to the next thing, because we still have another 79 candidates to evaluate.
I understand.
All right.
So,
Try one time, Mr. Rutherford.
Mr. Chairman, I don't have any other questions, just simply the comment that before we assert that things are black letter law, we ought to know what black letter law is at the current time and how it relates to what it is, the allegations that we're making, period.
Just-
That's it.
Thank you. Mr. Player, you disagree with that assertion?
Yes, I do.
All right, thank you. Is there anything else members of the commission want to ask about that is probative to the question of whether or not this candidate has satisfied the statutory and constitutional requirements for office? Mr. Sapp asserts that he has, and as we wait on bated breath, Mr. Sapp, you recognize.
No, just on the narrow issue now, as I was observing the exchange between Mr. Blair and Mr. Rutherford, it just dawned on me from the standpoint of the hearing itself. So you've got evidence being presented. Let's assume hypothetically that the evidence is violative of the law in its presentation, such that it ought not enter the record at all. Then the proper thing would have been for somebody to do what? Object to it coming into evidence, and then it's not a part of the record. So then the fundamental question now is, did anybody object to it coming in the record? Because we have waiver in our law all the time, right? I mean, when you don't object to something, you waive it. Things that are otherwise not admissible into evidence now become admissible because there was no objection, it was waived, and it's now part of the record. And so what, frankly, concerns me now, just on the ultimate issue of competence as it relates to being able to know the law and all of those kinds of things, is if you've got something that's not objected to and it's now part of the record, I'm not so sure.
I understand, and that is all of your prerogatives in making your evaluation.
But do you disagree in terms of the
Yes.
fact that, so you disagree that, hold on, you disagree that if something is being offered into evidence, that's objectionable, and if a party fails to object to it, and it becomes a part of the evidentiary record, that's somehow the judge's fault, if a lawyer didn't object to it. And you and I both agree, I believe, that if evidence is objectionable, then it's our job to do what? Object.
I think what Mr. Player would say, if I've understood his position correctly, is that notwithstanding the lack of objection, the judge should not have then still relied on that in making her order, or do I misunderstand your position?
The most fundamental is no communication with a 9 and 10-year-old for a year. That I don't understand, and what Mr. Rutherford misunderstood earlier is I said, if you can justify that,
Sure.
that it's not that she didn't give a justification. The other two were two statutory schemes, which I provided the statute. The statute doesn't say what Todd says it says. It hasn't been overruled as far as I know. I have no idea what year the opinion was, I mean, I don't know, I'm not saying he's wrong, but I haven't seen it. But regardless, the statute says it was confidential. And she blamed him for the mandatory report over which he had no, he had no control. So that was the misunderstanding.
I think I'm tracking with you, and I think we've done ample service to the
Yes.
commission and to the General Assembly as a whole, who will have the benefit of our, what will surely be a voluminous report, such that they can then give way to this discussion, however, the members of the General Assembly see fit. And I appreciate the commissioners and yourself, Mr. Player, for digging through that so that we could proceed.
Sure.
I'm not going to ask if there are any more questions. I think we've done enough of that. But I will give you a sort of display. Is there anything else you think we need to hit on?
No, I would just ask the commission to review the order and my comments and take it into consideration.
Mr. Chairman.
Thank you, sir.
I would be remiss, though, I want to thank you, gentlemen, for allowing us to engage in the exchange we did.
Absolutely, and I'm sorry if I got
You were not.
out of turn.
No, no,
I've been around Todd a long time.
So the rest of us, and,
That's
We all
right.
have.
yeah, we totally understand.
You might be off by 5, I
Yeah.
think it's 35.
But no, I just wanted to thank the gentlemen for allowing us to engage in the exchange.
Absolutely. Appreciate that, and thank you for your comments, sir.
Thank you.
Thank you, Mr. Player.
Mr. Gallman? Mr. Gallman, the commission,
Yes. Mr. Copeland, if you would please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Mr. Gallman, the commission has before it your affidavit of complaint, which I respectfully request be made part of the record at this time. The purpose of today's hearing is for the commission to review the qualifications of the candidates to determine whether Judge Bromell Holmes is qualified to be on the Court of Appeals. The commission is not here to relitigate a case, and they do not have the ability to change the result of your case. Mr. Gallman, you've submitted your affidavit, which the commission is reviewing. Is there anything else you wish to testify to, specifically regarding Judge Bromell Holmes' ethics, competency, or character that has not already been covered by the commission?
Yes, and I would begin by stating for a point of clarification, and I'll read my statement very brief, perhaps 3 minutes at most. But I'd like to start with a point of clarification. We completed a psychological evaluation that was completed in December of 2000.
Mr.
Hold on, I know what
Mr.
you're
Gallman, my responsibility
I understand.
Yeah, well, I don't think you need, the goal here is to provide additional evidence into the record.
And it's important that I establish this for the record.
Okay. All right. Briefly then, if you will, and
And now
before,
a brief statement.
well, we'll talk about that. Let's do this one first.
Okay. I want to make sure as a point of clarification, prior to the final divorce order, we completed a psychological evaluation. The guardian that was involved in that case is sitting in this room. That psychological evaluation was not put on the record, and I settled via consent order for 50-50 equal time and agreed in a no-fault divorce to pay $6,888.88 a month. Okay? So a psychological evaluation was completed. It was kept off the record because the plaintiff's attorney did not want that on the record. Subsequently, she got another attorney and filed to take the children away from me, and the judge was unaware of that. So I will grant her the benefit of the doubt. But there was a psychological evaluation that was completed, and in that 362 days and nights, I went to 2 other providers. I was completely exonerated, and I could put that psychological evaluation out on my ex-wife today, and could have put it out at any point in history. That would have hurt my children. And it would not have been in the best interest of my children. So I want to clarify that. And one other point of clarification.
Hold on. It's a weird system we got here, but when I press the button and need your attention, I need your attention so that we can stay focused on what we have to do here. And that is evaluate the candidate as related to the non-statutory and constitutional requirements, qualification requirements. To that end, you, I think, have made clear that there were additional evidentiary factors that mattered and therefore had a consequential effect with respect to your analysis of her satisfaction of those qualifications. So I think you made that point, and now I understand you wanted to make an additional point that's relative to your statement. I'm not going to allow a reading of a statement that has been submitted to the commission already because we have it in the record. And our purpose and our focus is on adding additional information, both for the benefit of the commissioners here, but also for the members of the General Assembly who will have to rely on this commission's report in making their decisions with respect to the election of judges and justices. So to that end, if you have additional things that you'd like to add, I'd be happy to hear from them. But again, I want to emphasize, this is not a forum to relitigate the merits of the case. And I empathize with you. I get it. I've been there. I haven't been in your shoes, but I can feel the passion. And so I want to be fair to you and to everybody involved in this process, and would kindly ask you to focus your comments again on the information that we don't have somewhere in a written form.
Thank you, Chairman Caskey. If I may.
Yes, sir, please.
Thank you. The other point of clarification that I would like to make is that the assertion that it could have been objected on the record was not possible, as this occurred at a temporary hearing where no one spoke. The judge took the information, called a recess, came back, and I will start with my statements. I want to make sure that the record reflects that it could not have been objected in a 15-minute temporary hearing.